But nevertheless, in addressing these particular challenges, we do have a vision, a strategic vision that we are trying to implement. Each administration ultimately arrives at a doctrine, the Reagan doctrine, the Bush doctrine. After 1 year, it seems to me that there is emerging an Obama-Clinton doctrine which can be exemplified in many of the things that the President and the Secretary have said over the last year, which are, I think, set forth in 4 basic commitments. First, a commitment to international engagement, not pulling back, but actually engaging. And that this is one that flows from a president whose father was from Kenya, who spent several years of his life in Indonesia, who emphasized in Cairo that the challenges of the 21st century can't be met by any one leader or one nation, who committed his administration to open dialogue and partnership across regional divides based on mutual interest and mutual respect. And indeed, this is an effort to take a different approach than some, the thought being that engagement, rather than withdrawing from institutions, even if these multilateral institutions are flawed, helps us to shape those institutions and make them serve broader purposes that we consider to be important. The second is a commitment to what Secretary Clinton called at her confirmation hearing smart power, a blend of principle and pragmatism, intelligent use of all policy tools, not just the military tool, not just hard instruments, but rather diplomacy, development, promotion of democracy, capacity for entrepreneurship and innovation, as a way of addressing a modern set of challenges facing U.S. foreign policy. A third is a commitment to values and the rule of law. The President has said this repeatedly. Fidelity to our values, he says, makes us stronger and safer. At Oslo, in his Nobel speech, he reaffirmed, adhering to standards, international standards, strengthens those who do, isolates those who don't. It suggests that following our values and following the rule of law may lead us to some constraints, but it also legitimizes what we do, and it helps us to resume a leadership position in global affairs. And fourth and finally, along with these commitments to engagement, smart power, the rule of law, and values, a commitment not to double standards but to universal standards. President Obama reaffirmed the basic ideals of human rights, and in her December speech at Georgetown, Secretary Clinton said a commitment starts with universal standards, holding everyone accountable to those standards, including ourselves. Now, this doesn't mean that we will always be perfect, but it will mean that we have a set of aspirations that we hope to achieve. Now, I know that on the 1-year anniversary of the administration, there's been lots of commentary. John Bellinger, I know, wrote an op-ed recently, the argument being that somehow the last year was characterized more by continuity than change. Now, I think anybody who's worked in the government knows that many of the policies don't change. You don't turn a ship in the ocean 180 degrees. But it seems to me that the key philosophy, stressing international engagement, smart power, a belief that diplomacy can accomplish as much as harder tools, a commitment to the rule of law, living our values, and the idea that global leadership will flow to those who obey these legal rules and will make us stronger and safer is a different kind of philosophy, and one that I think we are attempting to apply as a strategic vision. So you can point to all kinds of particular examples. I'm happy to explain how they fit within this broader framework. But make no mistake, whatever continuities there are with regard to particular issues, and in many of those things, I think our predecessors, particularly John, played a tremendous role in, I think, reversing positions that were taken earlier in the Bush administration. And continuity with lawful approaches, it seems to me, is to be applauded. Now, within this, what are the roles of the legal advisor's office? And I've suggested them already. The first, obviously, is counselor. I'm a general counsel of a large government agency. We have an employment unit, we have a buildings and acquisitions unit, we have a management unit. In this sense, we operate like any in-house counsel's office. It's just that our employment unit is talking about issues of contracting in Afghanistan. Our buildings and acquisition unit is trying to buy buildings in Fiji. Our management unit is managing issues of data disposition with regard to international matters. So in this sense, we are essentially following a lawyering agenda familiar to many of you, nearly all of you, answering questions that your clients ask you. We have 24 offices that mirror the State Department's bureaus, functional and regional, and they answer questions that come to them from their clients. But there's a second function as well, which is that we are not just answering questions raised, we consider ourselves to play a role in being a conscience of the department and the government with respect to international law issues. Abe Chase, my former professor at Harvard Law School, himself a former legal advisor, said, "It's the job of the legal advisor's office to hold the country to its own best standards and principles." Or as one former legal advisor, Herman Flager, put it, "Never say no when your law and conscience say yes, but never ever say yes when your law and conscience say no." And the idea that the lawyer is in the room both to give legal advice and, in a policy sense, to give policy advice about which of the available legal options make the most sense. And to identify for the client, if you want to do that, it is lawful, but it is awful. Then there is a third role, defender. The legal advisor's office appears for the U.S. in a whole range of international forums. I've had the good fortune already in my short time to appear for the United States before the International Court of Justice. We make submissions to all manner of international tribunals. Just this past 2 weeks, our office appeared before a NAFTA Chapter 11 tribunal. John Crook, a distinguished international lawyer, was one of the arbitrators with regard to a matter under the investment chapter of the NAFTA, the Iran-U.S. Claims Tribunal. The U.S. also appears regularly on international issues before domestic courts, and the legal advisor's office engages on those briefs as well. So in that sense, we are a defender of U.S. legal interests in these international bodies. And then fourth and finally, the legal advisor's office has traditionally been a spokesperson for U.S. positions about why international law matters. It's traditionally been connected to learned societies like the American Society, academic institutions, bar groups, and that's because of my own educational background is something I'd like to continue and expand while I'm in office.